Hello, everyone. Welcome to the final wintertime Workers' Comp 101. When next we do this type of webinar, it will be spring. And for those of you who are interested, I have the calendar here. We are going to be repeating this on March the 21st, if you want to see it again. Also bringing to your attention, next week at this time, we will be doing Workers' Comp 202. That is the second level of Workers' Comp webinar that we do. We go into more detail and deeper down. We call it a deeper dive. That's why it's 202. So if you would like to take that with us, that's next Wednesday, 10 a.m. Please sign up for that. But that's enough promo, Adam. Why don't we get started? Let's talk about how to create a safer workplace so that there isn't an incident ever, or as much as we can. Here is a tried and true method from organized labor, actually, that enlightened workplaces will use. We call it the Labor Management Safety Committee. What do you do? Pretty simple. It just involves talking and looking, and you make this committee with an equal number of workers and managers, and you get together on a predictable schedule, and unless you need an emergency meeting, and you talk about the procedures or the places in your workplace that are creating incidents or that could create incidents, and then mitigate it. Change whatever it is you're doing so that we don't have these incidents any longer. You might wish to review your equipment, might wish to review your processes and your training, just to make sure that everything is done in the safest possible manner. Workers' Comp is a no-fault insurance system. Yes, so two concepts there, my friends. Number one, no fault. Doesn't matter whose behavior caused the incident. That's what makes it no fault. And this is an insurance system. So that means there is an insurance payer somewhere in this equation who's going to actually provide those benefits. My agency, the Workers' Comp Board, we do not pay the benefits. Unless, and we'll get to the unless in a few minutes. The employers have to provide this coverage. And this is coverage that protects workers in the event of an injury that they incur on the job, or an illness such as COVID that they might incur on the job. And of course, employees do not directly contribute to the cost of this insurance. That's workers' comp. The other main insurance that we administer at this agency, is disability, which includes paid family leave, and workers can be asked to contribute to that, but just a really small piece. Can we provide the link to the Workers' Comp 201 webinar, Adam?
Yes, we can. If you go on our website, if you go to the Advocate for Injured Workers section, you'll see a link for our recorded version there. You can also go on our YouTube page. We'll have a link for that at the end of this presentation on a slide. And it's also there. You can watch it there as well.
Okay. So wherever you signed up for this webinar, you could sign up there too. Just look up webinars. But thank you for asking, and thank you for the interest. All right, workers' comp, your rights, as in you're the worker. Okay, here's what it comes down to. Workers are entitled to these protections no matter what. It's their legal right. You cannot sign it away. You cannot negotiate it away. And as a matter of fact, you can think of the benefits that I'm going to explain as a basis or a floor, because it is certainly possible to negotiate a richer benefit than what we're going to describe here. And as a matter of fact, if you're a part of a union and you have a collective bargaining agreement, you almost certainly have negotiated a richer benefit. Immigration status. We like to do this one right at the top because it's such a popular question, especially in New York, the state of New York, because we are a beacon for immigrants here in the great state of New York. Immigration status is not a factor. Immigration status is not a factor, period. Means, doesn't matter where you come from, doesn't matter where you were born, does not matter how you got here. These are not questions in our system, period. Also, immigrants sometimes don't speak English as well as they might wish to, or they might not speak it at all. If you're in the comp system, guess what? We at the board will provide you with translation, interpretation services as requested. So on screen, see that black column on your left? Those are the languages that we already have all of our materials readily translated into. And if you want one of our materials translated into a different language, just ask us and we'll do it. Also, if you're having a hearing, or if you telephone the board and you would prefer to speak a language other than English, we've got you covered. We will do an interpretation or a translation in whichever language you wish to communicate in. And of course, that is at no charge. We're the government, we don't charge you for these types of things. As a matter of fact, if you call my office, if you'd like to speak Spanish, we have a Spanish-speaking rep who will just take your call in Spanish. So this is the Workers' Comp Board. This is mine and Adam's employer. We regulate the workers' comp system. As far as state agencies go, we're not the biggest agency, but we do have close to 1,000 employees. We are operating about 24 places around the great state of New York. How do we do this? We receive reports of injuries and payments. We get the documents. If there's a medical bill and a report, it should be in the file here. If the insurance payer makes a payment or decides it doesn't wish to make a payment and wants to dispute that need, there's going to be a filing here at the board. And we will hold hearings in front of our law judges as appropriate. And we're going to speak more about how that works towards the end of this presentation. Who is the advocate for injured workers? Well, technically that's me. That is my title, and I have, or I should say I manage, the Office of the Advocate for Injured Workers. We are a group of people here at the board who help workers with the more difficult and complex claims. Technically, my title is Ombudsman, or ombuds. And an ombuds is a title that you tend to see at certain types of organizations, like a financial services corporation, or a hospital, or an insurance company. Those are the types of organizations that tend to have an ombuds because we care about the health of the system. We care about the sanctity of the system and how is it operating. That's really my title. That's really what I'm doing. And within those parameters, I'm helping workers with their most difficult claims. That includes fatality claims. We're involved in fatality claims. And as part of that, I do work, seems like still every day, with the 9/11 community. Because if you don't know, my friends, that is ongoing. People impacted by September 11 still need our help. And by our, I mean all of us. So, on screen you'll see, just bringing this to your attention, this is our website. There are 3 different assistance programs for people impacted by those events on that day. And since, reading from left, World Trade Center Health Program. Federal government is paying for health programs to monitor and treat people impacted by the events of September 11 and afterwards. In the center, the federal Department of Justice is actually operating the September 11 Victim Compensation Fund. So if that's you, you can visit this page and read here. You might want to be filing a claim with them. And then finally, yes, there is a workers' comp benefit, of course, for the people who responded, and of course, for the people who were the victims of the attacks. There's also a volunteer fund. This is the unusual thing. This is the only place in comp history in New York where volunteers can get a comp benefit because so many people did volunteer, both that day and in the months afterwards. All right, this is a foundational concept. Who pays your comp claim? There's going to be an insurance payer somewhere in the mix. The employer, the business, or the employer, they need to provide insurance to provide these workers' comp benefits. There are two ways that can be accomplished. First and simplest way is to buy an insurance policy. Adam, I just had reason to find out there are now 287 different insurance carriers who write comp insurance in this state. That number has increased, by the way. Adam and I do this every month, so the number changes. So if you're an employer, you can buy a policy from one of those 287 different insurance carriers. Or you can self-insure. Now, this one requires a little bit of detail. All governments in New York State can self-insure at will. If they wish to, go on ahead, they can. And most of them do, as a matter of fact. Now, when we say government, we're talking about a school district or a town or a county or a city. The biggest self-insured employer is the city of New York, for example. Now, if they're going to self-insure, what usually, but not always, but what usually happens is that self-insured employer hires a claim administrator, known as a third-party administrator or TPA. So what that means is the employer is not handling the claims itself. It hired a firm to handle the claims. So the reason I tell you this is if you're a worker and you get hurt on the job, if you go to your human resources department to ask them about your claim, they're not going to have any information. If you go to your supervisor, the supervisor is not going to have any information because they're not involved in your claim. The party involved in your claim is either the insurance company or the administrator if you're self-insured. It is also possible for a private employer to be self-insured, but the rules indicate that collateral has to be posted. So there are about 90 private corporations who are self-insured, but they tend to be multi-billion-dollar international corporations. Okay, Tony's Pizza in Batavia, New York is not going to be self-insured. Finally, if there's no insurance in place when there's an incident, the board, Adam and my employer, we will actually advance the benefit payments. And then we bill the owner of the scofflaw business for the money because there was an employer who should have been carrying insurance who chose not to for some reason. That's why I use the term scofflaw, because everybody knows you need comp. So just as we're saying, businesses with employees have to have this coverage. An employee can be one part-timer, okay? One part-time worker, yeah, you need coverage. And the worker is covered from minute one, by the way. There's no waiting period for the comp benefit to kick in terms of coverage. Also, if you're a not-for-profit, you're probably going to have the coverage as well. Let's look at this in a little more detail. It comes down to an employee. Who is an employee? We're using that term. Well, just remember that we're talking about who's an employee in the workers' comp context. So that means anyone who's providing services to a for-profit business, they can be determined to be an employee. And guess who makes that determination? The Workers' Comp Board. That's right. Please remember that. The employer doesn't make that determination. The worker doesn't. The New York State Taxation and Finance Department doesn't make it for comp. We do. And same thing for a nonprofit. There are very limited exceptions regarding who is not going to be covered for workers' comp in a nonprofit. Clergy and teachers in a charitable organization don't have to be covered, but they can be. Okay. So the important point here is to remember it's the Workers' Comp Board who's going to use the workers' comp rules to decide who is an employee. It does not just come down to a 1099. There are plenty of people who are eligible for comp who are getting paid on 1099s. And this does potentially include internet businesses, because there are very large internet-based businesses, like ride-sharing businesses, for example, who are carrying workers' comp insurance. So what do you do if there's an injury? You're a worker. What do you do if there's an injury? Now, here's what you do. Number one, get the necessary medical care, please. Our mothers were right. Take care of your health. Go get treatment promptly. And by the way, if you're an employer and you want to help your worker get treatment, that's fantastic. Thank you. You're doing a great thing. You don't have to try and go into the office and the exam room with the worker. I only mention that because I do get complaints about that. Yes, if you're a worker, you don't have to have your manager in the exam room with you. And you don't necessarily have to go to your employer's favorite urgent care if you're bleeding. Just get your treatment promptly. And then tell the employer in writing as soon as you can that there was an incident. You have to do this, workers, because your employer needs to know there was an incident so that your employer can tell the insurance payer that there was an incident. That starts a whole chain of events that yields a complete claim, which is what you want. Now, when we say in writing, you use email, use a document. You can text, it's legally permitted. I just don't recommend it because I dare you to go on your phone right now and find a text you sent 12 months ago. Because you might have to do that 12 months after your incident, by the way. So use a document, use an email, and then you can file the Form C3 if you're a worker. I'm going to go ahead and recommend that. Go ahead and make your own report. The C3, you're telling the comp board that there was an incident and you're giving some details. And here we go. We're showing you what it looks like online. We have this on our website. It's easy breezy online. You can just fill this in. If you can't manage to fit your claim details into this online thing, that is kind of possible. It is technically possible. That could happen. Then just send in the paper, okay? We're still taking paper from workers, no problem. We don't expect the workers to have IBM servers at home. You can still send things on paper. And what if the employee does not want to send the incident in writing? Do it. Do it. Okay, you don't want to do it, but just do it anyway, please. Tell your employer that there was an incident. There is this other little thing, like, let's say that the worker got so harmed that the employer called an ambulance and took the worker to the hospital. Okay, so in that instance, yeah, the employer had notice. You technically could get away with not telling the employer in writing, but I don't see why you wouldn't. Okay, take care of yourself, people. Yourselves, people. Okay, so keep getting your necessary treatment. You have 2 years after an incident to file the Form C3. Okay, 2 years. And now, a word from Adam.
Thank you, Joe. All right, we have a scenario up on our screen here that you'll see. I'm going to open up a poll right now, and I'm going to read this off to you. Joe and I want to get your opinion here. So we have Kadir. Kadir is not an American citizen. He's in the United States on a work visa. Kadir works 40 hours a week on site at a software company at a desk using the company's equipment on tasks that the company assigns him. Kadir works 8 hours a day. His start and end times do vary, and he does work on a 1099, so the software firm considers him to be an independent contractor. One day, Kadir is inattentive. He drops the computer server, and it fractures his left leg. The employer calls the ambulance. The ambulance takes Kadir to a hospital. So, what do you think in this situation? Should Kadir file a workers' comp claim? Again, there's a poll that we have up on your screen. If you want to just type in, or actually select your answer, either simple yes or no. We do have a few responses that have come in. We're going to give people a couple minutes to put your own responses in, and we'll get back to you. Right now, it looks like the majority of you are saying yes. It's not quite unanimous, but we do have it's pretty Joe. It looks like there's a landslide here. Most people think Kadir should file a workers' comp claim. What do you say?
I think Kadir also should file a workers' comp claim. I'd be interested to know if any of us who thought no, Kadir should not file a claim. If you want to indicate in the chat box why you believe Kadir should not file a claim, we'd be interested. But yes, we really do think that a claim is appropriate here. The key items for you to know are he's in the workplace. He chopped the computer server on his leg. He fractured it. He got treatment. That's pretty much the primary reason why we think that Kadir should file a claim. We put in some red herrings there for you about he's not a citizen, so what? He has a visa, so what? He was inattentive, so what? Remember, it's no fault. He gets a 1099. Okay, we gave you enough other reasons to think he would be considered an employee for comp purposes. And then finally, the employer called an ambulance, so that is pretty strong evidence the employer actually had notice. So thanks for that. We'll have another quiz later, but for now, let's move into benefits. All right, primary benefits in our system are medical care, lost wages, and a fatality benefit. So we're going to begin with the medical care. No cost. Okay, I'm sorry, I got distracted by a question that came in. We'll get to that. Medical benefits are provided at no cost to a worker for the medically necessary care for the body parts or the body sites or the illnesses that were work-related. And this is a lifetime benefit. Lifetime. For the rest of your life. So if you got hurt 5 years ago and you're having an exacerbation today or a flare-up, just go to the doctor. It's an authorized doctor, but just go to the doctor. And if you're an adjuster at an insurance carrier and you see that bill and you haven't had activity in 5 years, well, I'm trusting that you, because you're a licensed adjuster, you know that comp is a lifetime benefit. So if everything's in order, you'll just pay that. I'm obviously saying that for a reason, because this is a question that surprisingly does pop up a lot more frequently than I would think it ought to. Now, all the expenses are covered for medical care, office visits and surgeries and hospitals and testing. laboratory testing, PT, durable medical equipment known as DME, hearing aids. Hearing aids, my friends. Hearing loss is probably, in my estimation, the most underreported injury or occupational problem in the comp system. And also, transportation costs to and from healthcare appointments are reimbursable. In order to do that, you would file Form C-257. Okay? And C-257, it's very simple. You just know, where did you start? Where did you go? Where did you end up? Round trip. And you can use a mileage calculator like Google or MapQuest to calculate the miles that you drove. The key here is, if you're filing for reimbursement, the insurance company is going to reimburse you if there's a medical report in the file for that date of service. If there's not, you're probably not going to get reimbursed because you don't have any proof that you actually went to medical care. Okay, so that's a little wrinkle that I do feel compelled to mention, but it is reimbursable. So you're a worker. Let me give you some best practices for getting your medical care. Okay, let's go to the bottom one first. Arrive at all your appointments with your WCB case number. That's in the identifier we assigned you. It's going to be 8 characters. If your claim is from the last 15 years, it's probably going to start with the letter G, as in glorious. Have that number available, please, especially if you contact us. Your insurer is also going to assign a case number. It's going to be a dramatically different number, almost certainly. Have that available and have the name of the insurer handy so that when you go to the medical appointment, you can give the staff these 2 numbers and the name of the payer. Give them a fighting chance here to get paid. Now, you're going to this appointment. If you are temporary in your injury status, as in, no one has told you you have a permanent partial disability or a permanent total disability. If you have those things, you'll know, okay? You'll probably get that classified that way 2 years or so after your injury. But other than that, you're probably temporary. If you have a temporary disability and you're still out of work and you're still seeing the doctor, you need to go every 90 days, every 3 months or every 90 days. Reason is that doctor or provider is going to give you a degree of disability. How disabled are you? In order to get that lost wage payment while you're temporary, you need a degree of disability every 90 days. And you need it because it's one of the terms in the equation that the insurance company does to determine how much to pay you. So the lesson here is, you're temporary, go to the doctor every 90 days, get that degree of disability. Feel free to ask the provider what it is. Feel free to remind the provider to file it, because this is now a very gentle reminder to my friends in the payer community. Please remember, if we're talking temporary, you really have to be filing the degree of disability, work status, and causality. You probably know what those things mean. Here's another best practice regarding independent medical exams. IMEs. Okay, workers, pay attention. Insurance company might ask you to go to see its doctor. That's called an IME, independent medical exam. Here are some things you need to know. Number 1, you're not going to be treated. You are not going to get treatment recommendations or care. This doctor and it's almost always a physician, is going to give an opinion about some element of your health or your claim. How disabled are you? How much use have you lost in an injury site? That sort of thing. You can bring a witness. Don't let anybody tell you no. I'm telling you, you can bring a witness. You or your witness can record the exam. Don't let anybody tell you no. I'm telling you, you can. The reason you do that is because you are going to get a report filed by this doctor indicating those opinions. You can check the report against the video that you made with the audio. Make sure everything in that report is in that video. Now, if you find a discrepancy, if you have a lawyer, definitely show the lawyer, because it is definitely possible that a reading was measured and taken, and you don't recognize it as having been measured and taken because you're not a professional. But if you have a lawyer, your lawyer, they do this every day, so yeah, they might be able to see where it was taken. But if not, you can tell me. You can tell the Advocate for Injured Workers. If you have a complaint about the IME's conduct, as in, well, he said my arm is fully healed and nobody ever looked at my arm or tested my arm, or if by conduct you were treated in a very uncivil sort of a manner, you were not treated professionally, you were not seen in a medical facility, a medical type facility, or you're in a wheelchair and the wheelchair couldn't fit in the exam room, so they examined you in the waiting room. This is what we call conduct. You can make that complaint to my office. Finally, you can claim travel reimbursement from this exam too on Form C-257. And given the distances that sometimes workers have to travel, yeah, I'd encourage you to check that out. Different benefit. Benefit number 2 is the cash benefit, the lost wage benefit, we call it. Okay. What is it and how do we calculate it? The maximum amount you can get for losing time from work due to injury or illness is 2/3 of your average weekly wage. Your average weekly wage is, on average, how much you were earning per week for the 52 weeks before you were hurt. So we look back 1 year and we say, okay, for the year previous, this worker was earning $900 a week. Now the benefit is 2/3 of that amount. So let's say the worker cannot work 100% disabled. Well, that's a $600 a week benefit. Remember, it's 2/3 900, 600 is your benefit. It's tax-free, by the way. It's tax-free. So today's February 21. Adam, we're already getting the annual questions we receive every February about taxability of my workers' comp benefit. And am I going to get some sort of a W-2, W-4, W-58, whatever? Okay, so let me just answer that question now. It's tax-free, my friends. Your benefit's tax-free. You're not getting a tax form from us or the insurance company, frankly, because it's the insurance company who's actually paying you. This is tax-free. But all your compensation counts. Did you get overtime? It counts. Did you get a bonus? It counts. Did you get an allotment for uniforms? That counts. Okay, so we need to know about all your compensation. And also, do you have 2 jobs? More and more people seem to be having 2 jobs these days. If you have 2 jobs, if you can't work one, you can't work the other one either. So all compensation from all jobs counts. We call that concurrent employment. Now, the maximum benefit per week is on screen, 1145.43. That maximum amount adjusts every July 1st. It's based on the average salary of the average worker in the great state of New York. If you run the math on that, in the year 2022, the average worker was earning on average $89,000 in the state of New York. Don't feel bad if you're nowhere near that number because that's an average. That is not the median, that's the average. So if you have very wealthy workers like we do in New York, they're pushing up the average. The minimum right now is $275 per week. Now that minimum, I have to tell you, pertains to injuries from January 1st, 2024 forward. So if you're getting less than that for an older injury, I'm sorry, you're going to stay at that amount. You're not rising due to this change in the law, because the law changed on January 1st. After being stuck at 150 for 10 years, it went to 275, and it's going to advance in the manner we show you up on screen. In all instances, though, if the worker was earning less, if your worker was earning 270 a week, okay, then you would get 270 a week. Okay, you would get what you were earning. But that's the minimum otherwise. Now, these are lost wages. All the benefits are temporary at first unless you suffer a permanent injury. And I was talking earlier about the 100% benefit. You're 100% disabled. So you were earning 900, your benefit 600, that's 100%. Okay. If you're 50% disabled, you're going to get 50% of the benefit amount. Does this cover United States Postal Service letter carriers? No, it does not. This does not cover letter carriers who work for the federal government because they work for the federal government. The federal government employees have their own workers' comp system. You're not in this system. So I'm sorry. So these are all temporary benefits. Your degree of disability is going to determine how much of the benefit you get. By the way, that tends to come in 25%, 50%, 75%, 100%. It doesn't have to, but it tends to come in that way. If you can never work again, permanent total, you could have this benefit for life. You'd have 100% of the big benefit you were entitled to. And there's also temporary industrial disability. Those are two benefits where you can get this, the maximum rate for life. You can also get permanent partial disability, which would mean you're less than 100% disabled permanently, and you're going to get a benefit for a certain period of years. You can also receive a benefit that's called reduced earnings. Someone is asking the question, can you get benefits if an injury causes you to go from full-time to part-time? You're working less. Well, if that should happen and your earnings have now been reduced, you could get the reduced earnings benefit. And the way that works, we look at what you used to earn, we look at what you earn now. There's a difference there. You can get 2/3 of that difference. So yes. There's also a benefit if you should lose part of the use of a limb. Okay, you hurt your arm, you hurt your leg, and you've healed 100%, but you're not 100% healed. You've come to maximum medical improvement. You're as well as you're ever going to get. And the doctor says, well, I'm sorry, Mr. DeGrom, but you've lost 10% of the use of your arm. Okay, there's a benefit payable to you for that 10% use that you've lost. It's called the scheduled loss of use benefit. If that's you, it's going to come some years after the original injury. We have a pamphlet online about that. Finally, please note where you were working when you got hurt. This is really important in construction, particularly in cities. please try and catch the address of where you were actually working when you actually got hurt and tell us, because it will help us find the proper insurance carrier so much more quickly. I promise you that. Now, here's a best practice. If you can have a bank account, please consider direct deposit of your benefits. I'm not going to belabor this point, but I do hope that the fact I'm choosing not to belabor this point, you will understand how emphatic I'm being. If you can have a bank account, please consider direct deposit. Also, if you get paid in cash, that's fine. Cash is still legal tender, but maybe keep some records because you might have to prove what you got paid. Like, for example, lost wage benefit like we talked about. How are we going to look back 52 weeks? Well, keep some records, please. Just write down who paid you, when you got paid, what you got paid for doing, how much you got paid. Because if you show up at a hearing with those kinds of records and the other side has no records and just says, well, I think I was paying this or that, might put you in a much better position. Finally, there is a fatality benefit, as in a worker perishes due to employment. It doesn't have to be at that moment on the job site. We're showing you now a document that we created that has the benefits on it. Let's just run through it pretty quickly here. You see the funeral and memorial expenses in the traditional New York City metro area. New York City, Long Island, Westchester, Rockland, up to $12,500 is reimbursable for funeral and memorials. Reimbursable. Other than that, the rest of the state's $10,500. There is a weekly benefit payment available to surviving family. It's calculated the same way the maximum lost wage benefit is calculated. We first look for a legally wed spouse. The gender is not a factor. Then we look for children up to 18 or 23 if they're in accredited higher education. We also look for disabled or blind dependents. The kids will age out, and if there's a spouse and kids, they're sharing a benefit, the kids will age out, the spouse will, or whoever's left, their share increases. Disabled or blind dependents get it for life, just like the spouse does, unless the spouse gets remarried. Spouse remarries, you get a 2-year check, you're done. Now, if none of these parties exist, $50,000 is payable to the parents of the deceased worker. If none of those parties exist, $50,000 goes to the estate. If you're a distant relation, I'm sorry, you have to deal with the estate. There are 2 nonprofits who provide scholarships to the children of workers who are either deceased due to employment or very seriously, grievously injured. We like to point them out because we do believe in helping people. Kids Chance. Kids Chance of New York is the New York chapter of a national organization. You can see on screen here, kcnewyork.org. You can apply for a scholarship if this is you or someone you know. The other one we like to point out is the Triangle Shirtwaist Factory Memorial Fund. This group also gives scholarships to kids of deceased workers or very seriously, grievously injured workers. You can see on screen trianglememorial.org/scholarship. Google will find you these things too. Just pointing these things out to you because these organizations do exist. They are trying to help the children of workers who were killed or are very seriously injured. They're not for profits. We're not affiliated with them, but we still want you to know that they do exist. If this is you, contact them directly. We also should talk for a moment about COVID-19 claims. We're getting towards the end here, folks. COVID-19 is an infectious disease. infectious diseases are payable in the workers' comp system, at least in New York. Okay? The medical reports are going to be key here. So, everyone who's thinking to themselves, how do I prove I got COVID on the job? I know a lot of you are thinking that. Well, here you go. There's probably a positive PCR test. That should be filed because that's going to indicate you really had COVID. That's number one. If you get a PCR, if you get COVID today, you certainly can go and get a PCR test. You really can. I'm going to recommend you might want to do that because it's going to demonstrate pretty conclusively you had COVID. File it. Then the question becomes, where did you get COVID? Well, it's definitely possible to get it in the workplace. So you might want to see a doctor or a provider who can give a medical opinion on where you got COVID, because the standard we use is likelihood. Is it likely you got it at work? You don't have to point to a moment in time where you think you were infected. What we look at, is it likely? So, you want to talk to your provider about, did you have public contact? Were you wearing masks? Was COVID-19 prevalent in your workplace? That includes your coworkers. And to all the employers and insurance carriers who are listening to me right now, if you know that 4 other people had COVID the same time this worker had COVID, I hope you're taking that into account when you decide whether you're going to accept the claim or not. So your coworker's status definitely does factor into this. Also, if you're dealing with the public, like if you work in an emergency department and you're treating COVID patients, yeah, that's a relevant detail. Again, if you're an insurance payer, I hope you're noticing that when you decide if you're going to accept the claim or not. We have a fact sheet. We have a short video available on this whole topic on our website. We were pretty good on this, my friends. We had this out, I think, by June of 2020. We had all this guidance out there. So you can take a look at this if you wish, if you feel like it's helpful. But basically, if you think you got COVID on the job, why don't you file your claim? Because remember I said lifetime medical care? Well, suppose we end up dealing with long COVID in your case. You do have the lifetime medical care. Now, Adam has something to go over with you as well.
Hello, I've returned. So we have another scenario on your screen. Again, we want to get your opinion here. We have Liz. I'm going to open up a poll right now. Should be open on your screen. So Liz, she works at a big box store in the seasonal department during the holidays where she deals with the public. One day, Liz felt ill, so she called into work. Her PCR test for COVID came back positive. Now, during this time, Liz, while she was out, Liz did receive some paid sick leave for missing 2 weeks of work. Before she got sick, she was very vigilant about following COVID protocols. She wore a mask. She social distanced. So in this situation, we want to know, do you think Liz should file a claim for COVID-19 exposure? Again, there's a poll. We're going to give you a couple minutes here to put in your answers. It's just a simple yes or no. See, we have a smattering of responses now. We'd like to get a little more participation from everybody.
Yes, please participate, folks.
No need to be shy. There's no right or wrong answer. Joe and I are not judging you.
We are not sending you grades.
No, no, we are not. And all right, so we got a little more in here. Majority do say yes, that Liz should file a claim. We do have a smattering of no's. But Joe, what do you think Liz should do in this situation?
I think that Liz ought to file a claim. I think those of you who said no, I'm going to explain it, and if I still don't hit on your reason, tell us why you thought Liz should not file a claim. I think part of the reason people think no is because Liz received paid sick leave. Paid sick leave is a wholly separate benefit, and yeah, that's great. That's why we the state of New York put in paid sick leave. However, remember that whole thing about lifetime medical care? That's a pretty compelling reason to file the claim because you just never know where you're going to be in 10 years, what type of insurance you might have in 10 years, or whether you might need this in 10 years. Someone is asking a very big picture question that I absolutely cannot answer. Do I have any thoughts on whether COVID protocols will change with CDC recommendations? I have no thoughts on that topic. I have no thoughts on medical care, CDC, etc. I'm just a regular lay person in that way. There are penalties for late payment, my friends. Remember I was talking about telling the employer that you got hurt workers? You really need to do it because the insurance payers really do want to get the benefits out as quickly as they can because there is this standard. The benefits have to start flowing within 18 days of injury or 10 days from notice, whichever's later. Otherwise, penalties are possible. Also, let's say there's a decision from a judge. Decision's going to have a filing date on it. That's probably a day or 2 or 3 after the hearing itself. The money needs to be released within 10 days of that filing date, or there's a penalty possible, penalty payable to the worker, by the way. So workers, keep your eye on that stuff. Also, workers, the threshold for a penalty for an ongoing payment to be late is 25 days. Let's say you're getting paid every 2 weeks. You're used to getting paid on Tuesdays. You didn't get paid on Tuesday. Okay, I'm sorry. Maybe it came Wednesday, Thursday, or Friday. Maybe it came the next week. Okay, I really am genuinely sorry that your payment was delayed like that, but it's got to be 25 days late for you to get a penalty. And also, if there's an appeal, interest can be due when the appeal is decided. So if you're a worker, try and come back to work as soon as you're physically capable. Like, not like you're 100% disabled, but you're having a good day. No, that's not what I'm saying. I'm saying maybe you're down to 25% disabled according to your doctor. Maybe the doctor can write you some restrictions. And maybe you can go to your employer with those restrictions, physical restrictions. Don't lift more than 5 pounds, 10 pounds. Don't stand more than 20 minutes, 30 minutes. Doctors can do that. You can go to your employer with those restrictions and see if they can take you back and accommodate that. That's called return to work. That's called transitional duty. The most enlightened employers will do this. It helps the employers and their comp premiums. It helps the workers as well and their recovery. Also, let's talk about e-case. This is something that we urge. If you're an injured worker, sign up for e-case. We're showing you the website page where you can register for e-case. It's a piece of cake to register. And then you can see every document in your file. You can see what everybody else sees. Here is the not very extensive protocol you have to follow. Just fill in this, hit submit, and you'll get e-case access. Really recommend that to you. That'll also be helpful to you if you should ever have a hearing, because you might have a hearing. And it's going to be in front of one of our law judges here at the board. And the law judge will make some decisions and some findings of fact that impact your claim. Now, a couple of things you should know. Number one, it's not like Law and Order. There's no bailiff, there's no gavel, there's no robe. It's a little less formal that way, but we do still follow the rules of decorum, and witnesses can be called and so forth. There will be a procedure. The insurer is almost certainly going to send an attorney. So if you're an injured worker, if you want an attorney, you're allowed to retain an attorney. Of course you are. And then you would have the attorney speak for you. excuse me, all of our hearings today are still virtual. We are not yet reopened to the public, so we're all virtual. So that means you're going to have this virtual hearing, and if you wish, we would really recommend, I'm going to go out there on a limb, Adam. I'm recommending, number one, you attend your virtual hearing. Number two, you do it virtually, which is maybe you want to get the app that we have that you can get from Google or from Apple, or maybe you just want to look at your hearing notice. You will have directions on your hearing notice for how to connect virtually. You just need a camera and a microphone. So any smartphone, a computer that has a camera and microphone, really going to suggest you connect for the virtual hearing. And then you can see everybody else. And this is the technology, by the way, that allowed us to do all of our hearings during the pandemic. We didn't close hearings. We didn't miss hearings, unlike, say, the unified court system did. Okay, we're wrapping, folks. Follow the board. These are our social media presences. We have so much content available for you. You can follow us. If you follow us, promise, you're only going to get relevant content to workers' comp or paid family leave or disability. See that YouTube? Oh, it's okay. See that YouTube there, folks? If you want to see, Adam's going to remind you of this, but if you want to see any of these recordings of any of these sessions, they're on our YouTube page. Now, I think we'll probably leave up this slide. This is how you reach my office. We can answer any questions for you. But now, Adam, what do you say we turn to the questions in the chat box?
Yeah, I think it's a good idea. We do have a number of questions that were asked during the presentation. We are going to take a look at those. But real quick, Joe had mentioned the YouTube page. We did get a couple people asking if we're going to be providing a copy of the slide deck for this presentation. We do not provide a copy of the slide deck for the presentation. However, we do have a previously recorded version of this presentation. So if you go to our YouTube page, or if you go to the Advocate for Injured Workers page on the board's website, so you just go to our website, you see it there, wcb.ny.gov, search for Advocate for Injured Workers, the page will pop up. There's a resources section there that has a direct link to our most recent recorded version of this webinar. However, at this time, as I said, we did get a lot of questions come in, so Joe and I are going to take a quick break. We're going to review some of the questions that we did not answer during the presentation, and we will be back with you shortly. Thank you. All right, so we have a list of questions we're going to run through here to start. First question, Joe, how can you determine if an injury occurred at work?
All right. Let's say it's a trauma, as in you fell and broke your leg. Or let's say you're trimming a tree and you saw slips and hit your arm. Traumas are pretty easy. You just file it. The documents, when you file an injury, it's called self-effectuating, as in there is a basis to believe in what you're saying. However, once you file an injury, the insurance payer is going to look at it and make a call. They're going to either accept it or formally dispute the claim. That's called controvert, as in controversy. About 1 in 10 claims are formally controverted. So that means 90% of the claims are being accepted. Okay, so the insurance company has the first review of it, and that's how it goes over there.
All right, our next question here. Which businesses are exempted from workers' compensation coverage?
Not much. The Red Cross does not have to carry workers' comp insurance. Other than that, there's probably a workers' comp component to almost all the employers or businesses. The question might simply be, where is it? Like federal, for example, we mentioned federal government, federal employees have their own system. There are some employers in New York State who are not part of the state workers' comp system. Some easy examples would be the Fire Department of New York, Uniformed firefighters, they're not in the system. They have a special provision of law that pays for them. Police officers. Most police officers in New York State are part of this system, but there are definitely profound examples who are not, such as the police department of the city of New York again. The uniformed police officers are not part of the system, but their dispatchers are part of this system. So if you really have that kind of a question, you can ask us. But if you're thinking that there's a type of a business that's in the private sector that has people working there who might not be part of workers' comp, I think what you're really getting to is, are their employees going to be considered employees for comp purposes? And you can ask us.
All right, I want to take a quick moment now to take this time now to plug. If you are an employer or if you're in HR and you have questions about workers' comp in terms of your business, we do host a webinar for workers' comp with the Advocate for Business. That is also monthly. If you go to our website and go to our webinar page, you'll see the dates of upcoming webinars for that session. So you're welcome to sign up, and we can answer your questions at that one as well. Now, following up on that, Joe, would a business that has workers who temporarily work out of state also qualify for needing workers' compensation coverage?
They're working out of state. So if you're a New York-based employer,
I think they're asking if they're a New York-based employer, but their employees work out of state.
okay, so you sent your employee to a different state. Well, you have the policy in force. So you have the policy in force. So then if your worker gets injured in another state, you could be at that point where you have to decide which state you're going to file in. Because you might be giving us an instance where, yeah, you have a New York policy in force, but they're working in a different state. You might have to file in that state rather than filing in New York. So we're going to say this is highly fact specific. This one is going to turn on the particular facts of a particular case. So I can't give you a categorical answer. I could just give you these considerations.
All right, our next question here regarding Form C3. Is this the same form that the employer files with the insurance carrier?
No, it is not. C3 is the form that the worker files. There is a form that's a little work form, okay? It's an informal form. It's known as C2F, if you really want to get down into it. C2F. That is a form that employers can file with their carriers, their insurers, and then the insurers will file a notice with us. And that will be known as a first report of injury or a subsequent report of injury. So C2F is probably what you're thinking of.
All right, can you be fired for reporting an accident or for reporting a flare-up from a previous accident at work?
No, you shouldn't be. No, that's called discrimination or retaliation. If that happens, if you get fired for reporting an accident, you got yourself a discrimination claim there. You're going to file Form DC 120. D for discrimination, C for claim, 120. If you believe you got fired because you filed a claim, that is not permitted behavior. And it'll come here to the board for a hearing. And then if a judge agrees with you that this actually happened the way that you're saying, you can be awarded your job back. You can be awarded back wages. Our judges do have that authority.
All right, so what if you have to go to urgent care for your injury and they ask for a payment up front?
Don't pay it. Now, if it's an urgent care that's part of the, that's an authorized provider, well, they won't do that, and they shouldn't. Everybody should know the rules in this state of, no, you don't bill the worker directly when you're a medical provider like that.
Would any mental illness caused by a workplace injury or accident count for workers' comp?
Maybe. There is post-traumatic stress disorder, let's say. That's a mental that's a psychiatric problem that we do see in the system. Yes, we do cover psych illnesses, psych diagnoses in this system. Now, there is a particular standard that is used at the moment, and it has to do with greater than. Is the stress greater than what somebody typically sees in that role? But it is possible, yes, to have a psych claim in this system. It's going to depend on the facts again.
All right, next up, regarding lost wages, will the insurance company honor lost time that occurred prior to the injured worker seeking a doctor, providing the doctor that provides medical documentation with the dates the worker was unable to work?
Okay, this is a very answerable question. I'm just going to have to reframe it to make it a little easier to understand. Okay, let's say the worker is injured and goes to the doctor, and the doctor says 100%. You're 100% disabled. It is definitely possible for the benefit to begin from the date of incident. Even if the worker saw the doctor the next day or the day after, yes, the insurance company absolutely can pay it from day of incident because it's lost, or actually next day. Actually, you're going to get paid by your employer for the day it happened, and then next day is the first day you missed. So yes, that is definitely possible. We don't tend to have these little disputes of like a day or two in our system here. It's the situation for an injured worker is a lot more positive here than one might otherwise be fearing.
All right, what is someone eligible for lost wage benefits if their employment contract has ended, but the doctor has deemed them unable to work due to the injury?
Yes, your employment contract, that's fantastic, but we're not really interested in that. We're interested in the fact that you're working, you had an employment contract, you're working under your contract, you got hurt on this particular day, and you still are injured and your contract expired. It doesn't matter. All that matters is you were employed gainfully and fully on the day you got injured. There's an insurance company who's responsible for that claim. That insurance company keeps that claim in perpetuity unless you settle it. So you can change jobs. Your contract can end. It doesn't matter. Your claim is still with that insurance carrier.
All right, next question here. If there are changes after a scheduled loss of use, can we reopen our claim to get treatment?
I'm going to change this question a little bit because I'm going to expand it. All right. A worker received a scheduled loss of use payment. Means that provider said the worker lost some use in a limb, let's say 10%. Okay, so our questioner is asking us, can the worker still get treatment? Don't worry. Once your claim is established, you can get treatment for the rest of your natural life. Okay, I've said that a few times. Please take that to heart, folks. The treatment is yours. Don't let anybody tell you differently. Now, let's move to the other part of this, which our questioner might have been thinking, schedule loss of use. You got an SLU for a 10% loss. Let's say 3 years later, you've deteriorated to the point where you now have a 20% loss. Yes, you can come back. Get an exam, have the doctor show it and document it. You can come back for an additional payment as well.
All right, next question. How should a claimant prove they were contracted, I should say, COVID-19 at work?
Remember we were talking about this earlier? I'll go through it again. Do you have a PCR test? Go get a PCR test. That shows that you got it, that you got COVID. That's very important. How do you show you got it at work? You can go to a doctor and describe to your doctor where you work. What are the conditions? Did your coworkers have COVID? Do the people you work with have COVID? Tell the doctor or the provider, because the provider is going to give an opinion on the likelihood you got it at work. Did you wear masks? Did you deal with people who had COVID? So just give the details. You're going to get an opinion from a provider on the likelihood, or you're going to put it on your C3, and then the insurance company is going to make a judgment. They're going to look at everything, and they're going to say, should we accept it or should we dispute it? If they accept it, congratulations. If they dispute it, well, now you're going to have a hearing, and now you're going to get a chance to tell a judge all of these factors about your workplace, because remember, we're interested in the likelihood you got it at work.
Okay, we have a couple questions here, Joe, about retaining an attorney and who pays for it. Is the fee part of the comp case, and is it refundable?
Refundable? Wonder who. Okay, let me just explain to you what happens. Let's say you're a worker. Let's say you want an attorney. Okay, you're definitely entitled to, you're allowed to retain an attorney, and there are absolutely some cases where, wow, is it a good idea for you to get an attorney on this case? How do you do it? People ask us this question. How do you do it? Well, you can call the New York State Bar Association or go to the website. You can contact the Injured Workers Bar Association or go to their website, or you can come to the board website and you can look up licensed representatives. There are about 90 licensed representatives you can use. That's how you get one. The legal representatives do not receive any payment for services unless the worker shall receive some sort of a payment. So if it's medical only and there's no lost wages and there's no money paid, the attorney is not actually going to get a fee. But if there is money payable to the worker, the attorney is going to request a fee. The amount of the fee is pretty much dictated by law, and the judge will approve it. And then the insurance payer will send one check to the worker and one check to the attorney. And as a matter of fact, sometimes the judge will say it's payable to the attorney $50 a check in increments of $500. That's the kind of language they use sometimes. So the judge is going to dictate how it's paid, and it'll be paid directly to the attorney in a check from the insurance company. How's that, Adam?
Very good. All right. Next question. Board offices, will they ever be reopening?
Probably. We will let you know with plenty of notice if they or when they're reopening. I don't have a date for you right now, but I promise you, if we make an announcement and we get a date, we will certainly remind you in these webinars of the reopening date.
Excellent. All right. Lifetime benefits. Does that include, or does that continue after a case has been settled for partial permanent disability?
What a great question. This is a great question because our questioner, please don't feel funny, questioner, you're misusing an important term. We go over this in the 202. Settlement, settling. Our questioner is misusing the term settlement and settling. There is only one thing in this world that qualifies as a settlement in the workers' comp system. And that's when the worker and the insurance company agree to a contract that is going to pay the worker money today to permanently close the claim. That's a settlement. Now, Adam, let's reread this question, but let's change the word settled to paid.
Does the lifetime benefit continue after a case has been paid for a partial or permanent disability?
Okay. So, permanent partial disability means the worker is going to receive payments for a specific period of time, and the period of time is going to be between 4 years and 10 years. That's permanent partial disability, PPD. You're getting paid for 4 years to 10 years, and that's the amount of time. So, does the lifetime medical benefit continue? Yes, because the key word in the medical benefit is lifetime. Nobody wants to believe me today, but seriously, folks, when I say lifetime, I really do mean the rest of your natural life.
All right, we have one last question here. In terms of travel reimbursements, could you just quickly review the process again? And does the employer need to approve your request for travel expenses?
Great question. Here we go. There is reimbursement to workers available for travel to and from healthcare appointments. That also includes independent medical exams. That's what's eligible. The worker should use Form C-257. Form C-257. You can get it on our website. Pretty sure it's even in the list of most frequently asked for forms. So on that, you're going to note where did you start, where did you go to, and then wherever you went to, where did you end up? The round trip. You're going to give the date. If the medical bill and report is in the file, it should be payable. If it's not in the file because like the provider never billed it, well, you're probably not going to get reimbursed for that travel, and the provider's not getting paid for the care rendered. So finally, does the employer have to, the employer's out of it. We're not looking to the employer for anything. It's the insurance company, the insurance payer who has to pay this. There is no time limit either. So if your claim is 20 years old and you never filed for this, you can register for eCase, look at all your medicals in your file, and put in your travel reimbursement for the last 20 years of medical care.
All right, that is all the questions we have. So we are going to go ahead and wrap up. Before we leave, I do want to make one last plug for our Workers' Comp 202 webinar, which is next Wednesday, the 28th. If you want to go to our website, the webinar page, you can sign up for that. We hope you enjoyed today's session. We appreciate all the questions and the comments we got. Thank you to Joe, as always, for taking the time to give this presentation.
Thank you.
Just a quick reminder, you can sign up to receive workers' compensation news, including information on future webinars, straight to your inbox. To sign up, visit the board's website at wcb.ny.gov. Scroll down to the bottom of the homepage and select Get WCB Notifications. We also distribute information via social media, so make sure you're following the board on Facebook, X, Instagram, and YouTube. Again, thank you all for joining us, and please enjoy the rest of your afternoon.